the Supreme Court held an oral hearing on whether or not they should uphold the state of Colorado's disqualification of Donald Trump to run for president under Section 3 of the 14th Amendment, ratified in 1868 as one of the great Reconstruction amendments, the 13th, 14th, and 15th. And the amendment, to summarize it, Section 3 says, if you previously had sworn an oath to uphold the Constitution and then subsequently engaged in an insurrection or given aid and comfort to an insurrection, you are ineligible to run for a federal office. Now, this issue posed very important constitutional questions of interpreting the 14th Amendment and deciding whether or not it covered Donald Trump as someone who clearly had sworn an oath to uphold the Constitution and, in my view, clearly engaged in an insurrection. Instead, the court really sidestepped the most important and fundamental issues here. They didn't even raise the issue of insurrection until 53 minutes into Trump's lawyer's presentation, after lobbing meaningless softball questions at him. And then when they got to some of the key issues, they did not seem to have either read, for the most part, or understood the amicus brief that I submitted along with 24 of the nation's leading historians. Somehow, except maybe for Justice Sotomayor, that got completely lost, including by some of the court liberals. Justice Jackson seemed to say there was some ambiguity as to whether the president was covered under Section 3, as if those firmly anti-Confederate, firmly partisan Republicans who crafted the amendment were worried about an ex-Confederate running for dog catcher, but didn't care if they ran for president. There was no ambiguity, as we pointed out in our amicus brief. The issue was explicitly raised in the debates over Section 3 by an opponent, of course, of Section 3 in the 14th Amendment, Democratic Senator Reverdy Johnson of my home state, your once home state of Maryland. He said, why'd you leave out the president? And Senator Lott Morrill, a major supporter of the 14th Amendment, said, no, he didn't. He's covered as an officer of the United States. Johnson said, oh, I stand corrected, you're right. And no senator and no representative arose to challenge the idea that the president is clearly an officer of the United States. And if that isn't enough, 4 years later, the decision makers in Congress were passing an amnesty bill to allow the ex-Confederates who were disqualified under Section 3 to now run for office. And they explicitly excluded the former Confederate President Jefferson Davis because they explicitly recognized he was excluded from running for president under Section 3. But if they gave him amnesty and removed the disqualification, he could run for president. Again, there's no ambiguity here. Senator James Flanagan, a supporter of the 14th Amendment, said, quote, if the disabilities of Jefferson Davis were removed, the Democrats would not find it necessary to ask Congress to incorporate an additional amendment in the fundamental law to enable them to broadcast throughout the civilized world to find candidates for the presidency. No, sir. They would go no further than Jefferson Davis, who still lives. No ambiguity here. Jefferson Davis was disqualified under Section 3 for running for president, and they explicitly would not remove the disqualification because they were afraid the Democrats would nominate him for president. The other big issue was, does enforcement of Section 3 require an act of Congress? And again, there's no ambiguity here. Thousands of ex-Confederates, including Jefferson Davis, were disqualified the moment the states ratified Section 3 of the 14th Amendment in 1868. Not a single one of them including Jefferson Davis, was disqualified under an act of Congress, and not a single one of them was actually convicted of any crime associated with the rebellion. Look even further. Jefferson Davis tried to use his disqualification to run for president, which he recognized happened the moment the 14th Amendment was ratified, to try to quash his prosecution for treason, saying it was double jeopardy. And the two judges agreed that he was disqualified, but they didn't agree on whether it would quash the prosecution, and eventually the prosecution was dropped. No precedent for an act of Congress or a conviction. So instead of looking at the plain meaning and historical interpretation of Section 3 and determining, A, did the president, former president, swear an oath to uphold the Constitution? Of course he did. Did he engage in insurrection? Of course. Trump's lawyer gave an absurd argument saying it wasn't an insurrection, it was just a riot. Absurd. A riot is purposeless. This was not purposeless. It was directed explicitly at undermining our democracy, undermining our form of government by stopping the ratification of the will of the voters in the 2020 presidential election. None of the justices really challenged that. And in addition, Trump's lawyers made an equally absurd argument that you can't deny Trump being on the ballot because if he gets elected, then maybe 2/3 of Congress, which you can do under Section 3, will relieve him of his disqualification. Come on, 2/3 of Congress can't agree on how to spell their own names, much less on something this important. What is far more likely would be if Trump stays in the ballot, even though he's disqualified under Section 3, and then gets elected, you'll have an enormous constitutional crisis because the amendment says he can't serve, and who knows what might happen then. And so the court should have made the following determinations. Did Trump swear an oath? Of course he did. Did he engage in insurrection? Of course he did. The two courts, both courts in Colorado that looked at it, found he did after factual hearings. The January 6th committee found that he did. So he engaged in an insurrection. Is the office of the president covered? Of course he is. Does it require an act of Congress? No, he doesn't. What the Supreme Court seemed to want to do is just take an off-ramp, not deal with the monumental questions, but basically I think what they're probably going to do is say Colorado was wrong because individual states shouldn't be able to decide a presidential election. Well, the lawyers for the plaintiffs in the Colorado case answered that. They said, you're the Supreme Court. You're the supreme law of the land. The case is now brought to you. You can, in fact, as the Supreme Court, decide that Trump is disqualified. This argument about the problem of individual states doing it need not constrain you at all. Final point I want to make is, this idea we'll have chaos and bedlam. This is what Trump and his supporters are always threatening. If you apply the law against me, then, there's going to be chaos, violence, bedlam. You can't succumb to that kind of blackmail. You can't let that kind of blackmail deter you, whether you're the Supreme Court or any other court or a jury, from doing the right thing under the law and the Constitution.